In this lecture, we will discuss another important piece of legislation, and that is Maintenance and Welfare of Parents and Senior Citizens Act 2007. So, the Act defines as children include son, daughter, grandson, and granddaughter, but does not include a minor. Maintenance as defined includes provisions for food, clothing, residence and medical attendance and treatment. Here, minor means a person who, under the provisions of the Indian Majority Act 1875, is deemed not to have attained the age of majority, and that is the year of 18. Then also the Act defines parent, which means father or mother, whether biological, adoptive, or stepfather or stepmother, as the case may be, whether or not the father or the mother is a senior citizen. The Act also defines prescribed means prescribed by rules made by the state governments under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The Act also defines property, which means property of any kind, whether movable or immovable, ancestral or self-acquired, tangible or intangible, and includes rights or interest in such property. The Act also defines relative, which means any legal heir of the childless senior citizen who is not a minor and is in possession of or would inherit his property after his death. The Act also defines senior citizen as any person being a citizen of India who has attained the age of 60 years or above. The Act also defines state government or in relation to union territory as the administrator, therefore appointed under Article 239 of the Indian Constitution. The Act also defines tribunal as the Maintenance Tribunal constituted under Section 7 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The Act also defines welfare as provisions for food, health care, recreation centers, and other amenities necessary for the senior citizens. And the Act provides regarding maintenance of parents and senior citizens as a senior citizen, including parent who is unable to maintain himself from his own earning or property owned by him, shall be entitled to make an application as provided under Section 5 of the Act in case of parent or grandparent against one or more of his children not being a minor. A childless senior citizen against such of his relative referred to as per the provisions of Section 2, Clause G. Further, it provides regarding maintenance the obligation of the children or relative, as the case may be, to maintain a senior citizen extend to the needs of such citizen so that senior citizen may lead a normal life. Further, it defines the obligation of the children regarding maintenance to maintain his or her parents extend to the needs of such parent, either father or mother or both, as the case may be, so that such parent may lead a normal life. Further, regarding maintenance, the Act provides a person being a relative of a senior citizen and having sufficient means shall maintain such senior citizen provided he is in possession of the property of such senior citizen or he would inherit the property of such senior citizen. Further provided that where more than one relatives are entitled to inherit the property of a senior citizen, the maintenance shall be payable by such relative in the proportion in which they would inherit his or her property. Further, the Act provided the jurisdiction and the procedure regarding maintenance and welfare of parents and senior citizens. The proceedings under Section 5 of the Act may be taken against any children or relative in any district where he resides or last resided or where children or relatives resides. Further, the procedure as provided under Section 5 on receipt of the application. Under Section 5, the tribunal shall issue a process for procuring the presence of children or relative against whom the application is filed. Further, for securing the attendance of children or relatives, the tribunal shall have the power of judicial magistrate of first class as provided under the Code of Criminal Procedure 1973. It also provided that all evidence to such proceedings shall be taken in presence of the children or relative against whom an order for payment of maintenance is proposed to be made and shall be recorded in the manner prescribed for summons cases, provided that if tribunal is satisfied that the children or relative against whom an order of payment of maintenance is proposed to be made is willfully avoiding service or willfully neglecting to attend the tribunal, the tribunal may proceed to hear and determine the case expertly. Further, it provided where the children or relative is residing out of India, the summons shall be served by the tribunal through such authority as the central government may by notification in the official gazette specify on this behalf. Further, the tribunal, before hearing an application as made under Section 5 by the parents or senior citizens, may refer the same to a conciliation officer, and such conciliation officer shall submit his findings within 1 month, and if amicable settlement has been arrived at, the tribunal shall pass an order to that effect. Further, the very explanation as provided under the Maintenance and Welfare of Parents and Senior Citizenship Act 2007 regarding conciliation officer. It means any person or representative of an organization referred to in subsection 1 or section 5 or the maintenance officer designated by the state government under subsection 1 of section 18 of the Act or any other person nominated by the tribunal for the very purpose of conciliation. And now we'll discuss about the provisions relating to the power of state government to make rules. So the state governments may by notification in official gazettes make rules for carrying out the purposes of this Act. without prejudice to the generality of the foregoing power, such rules may provide for the manner of holding inquiry under Section 5, subject to such rules as may be prescribed under subsection 1 of Section 8 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007, the power and procedure of the tribunal for other purposes under subsection 2 of Section 8, the maximum maintenance allowance which may be allowed by the tribunal under subsection 2 of Section 9, the scheme for management of old age homes, including the standards and various types of services to be provided by them, which are necessary for medical care and means of entertainment to inhabitants of such homes, and as provided under subsection 2 of Section 19 of the Act. The powers and duties of the authorities for implementing the provisions of this Act under subsection 1 of Section 22 of Maintenance and Welfare of Parents and Senior Citizens Act 2007. So, also the powers and duties of the authority for implementing the provisions of this Act as provided under subsection 1 of Section 22, a comprehensive action plan for providing protection of life and liberty and property of senior citizens as provided under subsection 2 of Section 22. Any other matters which is to be or may be prescribed, so the state government can make rules, and every rule made under this act shall be laid as soon as may be after it is made before each house of state legislature, where it consists of 2 houses or where such legislature consists of 1 house, so it must be before the house. And there are certain important questions that relates to the Maintenance and Welfare of Parents and Senior Citizens Act 2007. So, one of the important questions frequently raised that do a senior citizen or a parent have a right to maintenance under this law, and how one can claim maintenance. A senior citizen above the age of 60 and are not able to take care of oneself properly from their own earnings or from their property, so they can file a maintenance application against their children who are above the age of 18 or against the grandchildren who are above the age of 18, or if they don't have children, from their relatives who are above the age of 18 and who are using their property or would inherit their property. So, such senior citizens, those who have no children, the relatives, against the relatives they can file a petition, would generally depend on the religious law of respective senior citizens as applicable to themselves. It could. So, another important question: if a senior citizen executed an agreement with a friend for provision of maintenance, then that senior citizen can approach the maintenance tribunal if it is not being honored or respected. It is possible that a senior citizen may make alternative arrangements for taking care of oneself in their old age, given that they are not able to take care of their family estate. They might have transferred the property to a friend or sold it to a provision for themselves to receive maintenance. So, a senior citizen, if executed an agreement to transfer their property to someone, say through a gift deed, with the condition that their basic needs will be taken care of and their friend does not honor this, they can apply to maintenance before the tribunal for help. The court can pass an order declaring that the agreement is invalid and the senior citizen will be the legal owner of the property again. And in another situation, suppose the senior citizen has the right to receive maintenance out of the proceeds of a property, and if this property is later sold to someone else who knew the senior citizen had such right, or if this right is gifted or willed away, so the senior citizen have a right to claim maintenance against the person who now owns the same property. So, another important question that if a senior citizen is an adoptive parent, can they file a maintenance application if they could not take care of themselves? Yes, the law does not distinguish between birth parents and adoptive or step parents. The duty on children to support parents include adoptive parents and step parents. So one can file an application against the adopted child or stepchild for maintenance. So now the question arises regarding making application for maintenance by the senior citizen. One can file application in a maintenance tribunal under this act. The maintenance tribunal is a special court set up under this law. So, there are 24 states and 6 union territories, those who have already set up appellate tribunals. And those states and union territories having appellate tribunal regarding maintenance and welfare of parents and senior citizens as per the provisions of the Act of 2007 are Andhra Pradesh, Arunachal Pradesh, Assam, Bihar, Chhattisgarh, Goa, Gujarat, Haryana, Jharkhand, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Manipur, Meghalaya, Nagaland, Odisha, Punjab, Rajasthan, Tamil Nadu, Uttarakhand, West Bengal, Sikkim, and Tripura. The state government of Uttar Pradesh and Mizoram have not constituted appellate tribunals. So far, all the union territories except Lakshadweep have constituted the appellate tribunals as provided under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. So, maintenance tribunals have to be set up by state governments in its subdivisions. The and this court has the power of a normal civil court and can issue summons. So, where you can, particularly in those areas, a senior citizen can file the application. A senior citizen can file application in the maintenance tribunal in the area where he lives currently or have lived in the past, where their children or relatives live. So also another provision relates to that a senior citizen cannot file an application for maintenance under the Code of Criminal Procedure as provided under Section 125, which also provides the right to maintenance of these parents and senior citizens, and side by side under this law. So here the senior citizens has to remember there is no cap on the amount of monthly maintenance one can seek under the code. However, it could be lengthier process. So these are the important provisions and important questions that relates to maintenance and welfare of senior citizens and parents. So there are many such questions which rest relevant in the context of Maintenance and Welfare of Parents and Senior Citizens Act 2007. So another important question that relates to that, how can a senior citizen get maintenance while the particular case is going, whether he could get? Yes, a senior citizen can make an application to the court to order their children or relatives to pay them temporary maintenance on a monthly basis. So the court has to decide on whether one can get temporary maintenance within 90 days of informing their children or relatives of their application. In special circumstances, the senior citizens or their children can delay this for some time, only 30 days. And this is not the final maintenance as a senior citizen accept to get. So the court may decide not to give maintenance at all, or may decide to increase or decrease the amount of maintenance in the final order. So another important question arises: can a senior citizen file a maintenance application against more than one child or relative? The answer is yes. One can file a maintenance application as a parent against all their children. All of them have a duty to maintain their parents. As a senior citizen without children, can one file maintenance application against any relatives or all relatives who possess or who will inherit their property? If there is more than one such relative, his relative is supposed to pay maintenance in proportion to the property that they will inherit from the senior citizens. And another important question that also arises: So when the parents have filed a maintenance application against a child or children, can one involve his brother? Yes, if both the siblings or other relatives who are legally supposed to maintain the parents are senior citizens. So also one can file an application to get them involved, all the children in the case. So also another question arises: if the children passed away after she had been ordered to pay maintenance, are the other children allowed to stop paying maintenance? No. The answer is no. Once a court has passed maintenance order against the children or relatives, they have to follow it. The death of any one of the children or relatives cannot be used as an excuse. The other children or relatives will have to continue paying such maintenance to such parents and children. So, if a child or the children do not follow the maintenance order of the court, in that case, what would happen? So, in that case, the senior citizen or the parents can make an application to any maintenance tribunal within 6 months of them not paying the maintenance. The court can impose a fine on the children for the maintenance amount and expenses of the proceedings. The children can also be punished with jail term of up to 1 month if they pay off before the end of the jail term. They will be released. So, another important question relating to that: if a parent or senior citizen is unhappy with the maintenance order, then what they can do? So they have the right to appeal if they are a senior citizen who is unhappy with the order. According to the law, as a child or relative against whom an order has been passed, the parent or senior citizens do not have the right to appeal. However, certain high courts have held that the right to appeal is available to both the parties, the senior citizens' parents or the children. So also, a senior citizen can appeal to the higher or more senior courts known as the appellate tribunal. Meanwhile, the children have to comply with the maintenance order. So also, senior citizen can file appeal within 60 days of the order from the maintenance tribunal. So now we'll discuss another important question involving maintenance and welfare of parents and senior citizens act relating to punishment for abandoning senior citizens. So, if anyone leave a senior citizen at some place with the intention of abandoning them and not taking care of them, such children can be punished with jail term up to 3 months and or a fine of up to rupees 5,000. The police can make an arrest without the permission of a court. However, this is a bailable offense if one is able to pay the bail bond. Then such children will be released. So, these are the very important questions and frequently asked why. So, if a senior citizen filed a maintenance application under this rule, So they can ask help of the government appointed maintenance officers. So also the state government have a duty to set up old age homes in its districts for senior citizens who are unable to support themselves, and this is to be implemented in a phased manner. Further, the act mandated the state governments have a duty to provide medical support to senior citizens in government aided hospitals, providing treatment for chronic and terminal diseases and arrange separate queues for them. So, these are the important provisions and those frequently raised relevant questions relating to maintenance and welfare of parents and senior citizens as provided under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. So we have completed our lecture on this very important piece of legislation enacted by the Union Parliament of India in the year 2007 as Maintenance and Welfare of Parents and Citizens Act 2007.